Hello, my name is David Petrosky. I'm a landlord attorney, and today I'm going to be discussing the Landlord Unbundled legal services plan that we offer for landlords who want to manage and represent themselves, but they want a little bit of guidance and support on the documentation, because the documentation in an eviction case is very, very important. So let's first dive right into the plan where we would create the initial pleading documents on an eviction case. This would include the summons, the cover sheet, any addendums that are required to the cover sheet, as well as the summons and the complaint. And under this option, we would create all of these initial pleading documents for you, and then we would submit these forms back to you, and then it would be your responsibility as the landlord to have the paperwork filed at the courthouse with the court filing fee, unless you're getting a fee waiver. And then you would need to have the tenant served, and you would need to make sure that you are paying close attention to any deadlines and filing any subsequent documentation timely in order to move your case along without any unnecessary delays. So under this plan, we would again create your initial court pleading documents, and then you would file it and represent yourself in court. But before we get to that step, before you're filing the initial court documents, you first have to normally give the tenant a termination notice. It might be a notice based on non-payment of rent. It might be a notice because the tenant is violating a term of the rental agreement. Maybe they're smoking when the lease says no smoking. Maybe they're causing a nuisance, or maybe you just don't want to rent the property anymore, or you want to sell it. Normally in these types of situations, you need to first create and serve a termination notice on the tenant. And the court is very, very strict on the contents of the notice and the way it's served. So under this plan, we would create the termination notice for you so that it conforms with all applicable rules, and then you would have it served on the tenant. We can also draft a request for a default. And at this stage of the process, you've already filed the case in court, and the tenant hasn't responded. Essentially, they've ignored the case after being properly served. They have a certain number of days to respond to the eviction lawsuit. But if the tenant fails to do that, then the landlord would request a default from the court. And oftentimes, landlords fill out this paperwork incorrectly, only to have it rejected by the court. And by the way, if the landlord submits a faulty request for default and the court rejects that a few days later, and then in the interim, if your tenant files some sort of a response, well, then you're kind of out of luck, because you're going to have to, at that point, probably move forward to a trial. Whereas if you had submitted a correct request for default initially before your tenant filed any response, then the tenant would be cut off from filing that responsive pleading. So it's very important that your request for default be done timely and correctly. So under this option, we can request the default, fill out that paperwork for you, and then you would file it at the courthouse. We can also draft a writ of possession. This is when you would file with the court after you've already received a judgment for possession of the property. Once you receive that judgment for possession of the property, then you need to enforce the judgment in case the tenant doesn't move voluntarily. A lot of times tenants won't move even after you get a judgment against them. So under this option, we would draft the writ of possession application and the actual writ of possession, and then you would file it at the court with the court filing fee. And then what the court does at that point is they will issue the writ of possession. You might have to drop it there, and it might take a few days to get it back, but then that's what you need in order to enforce the judgment. Once the court grants the writ of possession, then they will send it back to you, And then at that point, you'll need to deliver the original writ of possession with copies to the sheriff department. The sheriff's going to be the one that goes out to the property to evict the tenant. That'll be the very last step on the eviction case. So under this option, we will create the correct documentation for you for the writ of possession. We can also draft a settlement or a move-out agreement if during the eviction process, both you and your tenant agree to a move-out plan or a payment plan or a combination of both. Then we can draft the legally enforceable written document that would spell out the terms of the agreement that you've reached with your tenant. And then if a party fails to honor that agreement at a future date, then you can use this document in court to assist you in the future if either party decides not to honor the terms of the agreement. If you'd like further information, come to my website, which is attorneydavid.com. Again, that's attorneydavid.com. You can also read our evictions blog. There's a link to it right there, and it's also on the website. And you can download several forms on the website as well that would assist you on an ongoing landlord-tenant relationship. Finally, follow us on YouTube and like us on Facebook. I do publish articles frequently on the blog, and I update Facebook with landlord-tenant information almost on a daily basis. Again, we offer free consultations for landlords. If you're in our service area, go to our website, attorneydavid.com. Thank you so much. Bye-bye.